Okay, back on the record, let the record reflect that Mr. Coleman, Ms. Schilder here, Mr. Udishin, Ms. Gilbert, and Mr. Garner. Mr. Coleman, you may call your next witness.
Your Honor, the state calls Dr. George Edwards.
And Dr. Edwards, were you sworn already the other day?
Yeah.
I thought so. Come on in and have a seat, sir. Come on up.
It's okay, I believe things right here.
Yes, sir. And if you'll just kind of pull that microphone over a little bit. Perfect. You may proceed.
Thank you, Your Honor. Dr. Edwards, please state your full name for the court reporter, sir.
George A. Edwards.
And Dr. Edwards, what do you do for a living, sir?
I'm gainfully unemployed.
Meaning that you are retired?
Yes, sir.
Retired after doing what and for how long?
I have practiced pediatrics since I finished my fellowship training in 1978 up until the time of my retirement, which was in 2015.
Do you still maintain board certification in general pediatrics?
Yes, I still have my certification in peds.
And what about a sub-board certification? Do you have that?
No, I was sub-board certified in child abuse pediatrics under the American Board of Pediatrics. But to maintain that sub-board certification, you have to recertify. And since I've been retired, I haven't had malpractice insurance because you gotta make enough money to pay the premiums. So I have not gone through the issues of recertifying in child abuse pediatrics, but I have a lifelong certification in general pediatrics.
Very good. Forgive me if I missed it. How many total years experience do you have?
Oh my goodness, I have to take off my shoes to count that. Well, I got married in 1976, and that was 2 years before I finished all my training. So I've been practicing pediatrics. This is we're gonna have our 50th anniversary next month. So
Congratulations.
48 years.
Very good. I want to talk a little bit about your affiliation with the Dell Children's Child Abuse team, consult team, and also your affiliation with the University of Texas Dell Medical School. Please briefly for the judge, explain your affiliation there.
With Dell Children's Medical Center. I was the residency program director there, and I was doing inpatient pediatrics like a hospitalist. When, for various reasons, forget exactly, around 2000, we made a decision, my supervisor and my superior and I, that start doing consultations in child abuse. And that became my main clinical work and remained so until I retired. So I was the inaugural director of the child abuse program at Dell Children's.
And you are also with UT Dell Medical School from its inception as well, correct?
That's correct. When the new Dell Medical School at the University of Texas was finally created, I received a faculty appointment.
All right, I'm going to pick up the pace here. The only reason why I'm spending a little bit of time on this, because I think it's important for this judge to know who is providing and what you're basing your opinions on and your experience. And I think it's also important for the court of appeals to know. You are published. You've published articles that have been peer reviewed in journals that include the American Medical Association and the Journal of the American Medical Association and the Journal of Pediatrics. True?
Yes, I have published in, yes.
Participated in clinical research, and you continue to participate in clinical research even though you're retired. True?
That is correct.
You've taught. You've actually been a professor or associate professor with 4 different universities. True?
Yeah, I think that's right. UTMB, UT Austin, Dell Medical School, and yeah, that's right. UT Southwestern.
Goes without saying, you received numerous awards, recognition, served on various committees, and have been a member of a number of professional societies. True?
True.
You've made numerous lectures and presentations, and that includes a presentation or presentations to the National Center on Shaken Baby Syndrome. True?
True.
Testified in court on many occasions and as a expert witness on many occasions. True?
Yes.
And you, what about the Robert Roberson case? You're not involved in that directly, but you did write an opinion piece on that, correct?
That is correct.
And that opinion piece appeared in the Dallas Morning News.
That is correct.
All right. So much for your background. Let's talk about your review of the case file in this particular case. I, or the district attorney's office, asked you to review the case file involving the death of then 2-month-old Kaylin Garner, correct?
Yes, sir.
As part of that review, there were many documents, and what did they include as best you recall?
Transcripts of the trial, statements to police, CPS reports, medical records from St. Elizabeth's and Texas Children's. What am I leaving out? That's most of it.
All right, I think that's a good snapshot at least. After reviewing those documents, you prepared an affidavit that contained your conclusions, correct?
Correct.
I'd like to walk through that affidavit now, if we can. The ultimate conclusion, as I have it listed here, were that the injuries caused to Kaylin Garner were caused by physical abuse, specifically abusive head trauma. Is that fair to say?
Yes, sir.
Let's kind of walk through what led you to that conclusion. First of all, you indicate there was no evidence of an underlying disorder.
That is correct.
What kind of disorder or disorders would you have been looking for?
I think that this ground has been plowed by previous witnesses, but the massive brain swelling might have been the result of an infection, or might have been the result of a metabolic process, but there was no evidence of any kind of pre-existing condition that would predispose to this kind of severe, massive, life-threatening and ultimately life-ending brain injury.
You characterized it as being an abrupt onset of signs of massive brain swelling, that included unresponsiveness, quote, not breathing normally, and seizure-like activity. Can we unpack that, please? Let's talk about the abrupt onset of the massive brain swelling. In your training experience, what is that indicative of?
Well, this child clearly had something very serious happen between the time that he was acting normally before the mother left for work and the time that the CPS worker made her unannounced visit. I don't recall, I'm not sure that I actually counted the number of hours. It was maybe from 5 in the morning to about 2 in the afternoon. The child went from being normal to not breathing on his own and unresponsive. I consider that a very abrupt onset.
You also noted in your affidavit that there was no history of trauma. With these type of injuries, based on your training experience, what are some of the typical signs of trauma that you would see?
Well, sometimes they can be subtle, although the onset with this child, not subtle at all. You can see vomiting, you can see lethargy, you can see seizures, and many of those things are non-specific that you may see with other problems. That's one reason that sometimes the diagnosis is missed and children slip through the cracks.
You also noted a change in the defendant, who was the sole caregiver at the time, his story, or right, as you, I think you characterized it as the narrative regarding trauma. What I'm getting at is this whole business about accidentally striking Kaylin's head on the door frame. In response to that, you noted in your affidavit that there was no bruising or swelling at the site of impact, and there was no skull fracture or localized brain contusion. I mean, why would that be, in your opinion, something to note?
Well, just if I may,
Please.
to go back slightly, I'm sorry. Yes, the narrative of, let's say the history leading up to this event evolved over a period of time. Initially, there was no trauma. Uh, uh, and there was a history of what I would consider to be minor trauma with a bump on the head. And then there was a history of some shaking. Um, and that evolving narrative raises in my mind concerns uh, about abuse when you've got an injury. Now, the other part of your question, could you refresh my memory real quick?
Sure, there's no bruising, no swelling at the site of the impact. Additionally, no skull fracture or localized brain contusion.
I thought those things were important to pay attention to because the history that was subsequently given was of a minor bump to the head. If indeed that bump had been hard, uh, I would expect some evidence. You know, if you get a hard impact to the head, you get a goose egg, or maybe you get a skull fracture, or maybe if it's hard enough, you get contusion of the brain. That's like a bruise in the brain. But Kaylin didn't have those things.
Is it fair to say the lack of those things or was inconsistent with the massive brain swelling that he had? Is that a fair characterization?
No, I don't think the lack of those things. You were asking, were they consistent?
No, I'm sorry, inconsistent. But the lack of the evidence of bruising or some skull impact, is that inconsistent with the nature, the level, severity of the brain injury?
Uh, I'm not. I wouldn't exactly put it that way. I think what I would say is that if that impact had been the cause of his brain swelling, then I am very surprised that there wasn't any evidence of that impact on physical exam or on imaging.
Yes, sir. Would you characterize, at least if you buy it or if you don't buy it, whatever the narrative was or story that the defendant gave at the time, would you characterize that as an admission?
Well, yeah, I think so. I mean, I'm not sure what to make of it. Um, uh, you're referring to the second, I mean, the third police statement.
Yeah. Actually, when he also admitted to shaking in an effort after the doorframe strike, he admitted to shaking in an effort to resuscitate or get, as he put it, get the attention of Caitlin.
Yeah, uh, he did indicate that he had shook the baby. However many, it was over a week after the collapse of the child. There were two reasons that I saw in those reports that he told that he might have shaken. One was to get the child's attention. The child was unresponsive and he was trying to get the child to respond, was the way I understood what I read. But I also read that he said that he did the shaking in order to calm him down. And I thought that was remarkable because didn't make sense to me that you're trying to do both of those two things with shaking.
And if it didn't make sense to you, is it fair? I'll withdraw that. Was there a delay in seeking medical treatment?
Oh, I really think so. Again, going back, I think it was, I hope I'm not getting confused. I think it was in the second statement to police that the father described the child's eyes rolling back in his head and the child was unresponsive to him. You know, those, even if you don't have much experience with children, I think those are pretty alarming things. But uh, there was no call to 911. There was no call, no effort that was documented in the records I saw to seek help. And indeed, there was no action taken to um, to provide help to this child who turned out to be on death's door until an uninvolved party, well, I shouldn't say uninvolved, till a different party, the CBS worker made that unannounced visit in the afternoon, at which time then the child was brought straight to the emergency room.
And based on your training and experience, a delay of this nature in seeking medical attention under these circumstances, what is it potentially indicative of?
Well, it really raises a red flag. Um, you know, in my experience, I've seen cases where children with very serious injuries had delay of care. You know, I'm thinking in particular about one case that made a big impact on me, where a father uh, remorsefully admitted to having shaken his baby, who subsequently died. And, you know, he described to me how he had shaken the baby, and the baby, immediately afterwards, he put the baby in the child's bed, hoping, and left him there. And while he had left him there, he was hoping the child would recover. And when he went back, the child had not recovered, and that's when he started doing things. You know, that's only one case, but I do think that sometimes when bad things have happened, the person who may have unfortunately done the unfortunate thing hopes that, hey, maybe this kid's going to recover, and I won't have to worry about accountability or whatever. That raised a red flag for me.
All right. You also noted extensive retinal hemorrhaging, bleeding in the back of the eyes that was found in both eyes, and you characterize it as both too numerous to count and present in multiple layers and extended from the central area of the retina out to the periphery. What does that suggest in your training and experience?
Yeah, that's what I put in the affidavit, but that's based on what I found in the records. That retinal hemorrhages with that distribution and pattern um, uh, uh, strongly suggest, or I probably should say indicate, trauma. They are seen in victims of motor vehicle accidents, the victims of crush injuries, where something heavy has fallen on your head. Um, uh, they're seen when there is significant trauma, and in the absence of uh, an adequate explanation of trauma, an adequate history of trauma, they suggest abusive injury.
And when we're referring to your review, and I don't know that I was clear with the other witnesses, your review of the records, we're talking about not only the statements made or reports of Dr. Fernando Stein and Patricia Moore, there were medical records in those files that you and the other doctors reviewed, correct?
Correct,
Medical records from St. Elizabeth's Hospital, correct?
correct.
Medical records from Texas Children's Hospital?
Yes,
I
sir.
just want to make it clear on the record that we're not talking about you just simply regurgitating what was taken down or noted by Dr. Stein or Dr. Moore. You also noted that there were.
If I may say, you know, the trial record is very voluminous. And if you try to get your information from the testimony, I mean, you can and you need to go through it, but it's, it's, for me, it's a lot easier to look at the medical records to understand, those kind of records I can deal with. I'm sorry,
You speak
my
that language.
daughter's a lawyer, but, but nonetheless.
You speak that language. I get it. You also reviewed, as you put it, head imaging. Is that X-rays, scans?
That's the CT of the head.
CT scans. They also indicated massive brain swelling. But you also noted that there was no bleeding between the skull and the brain, what would ordinarily be referred to as intracranial hemorrhage or subdural hemorrhage. What, if anything, is noteworthy about that?
Well, subdural hemorrhage is a very, very common finding in abusive head trauma. So you see a child this ill with traumatic findings, but no history of trauma, you're a little bit surprised that there's not a subdural hemorrhage. But interestingly enough, there was a study that documented a number of such cases that they were children who were diagnosed with abusive head trauma that, very similar to Kaylin, had brain swelling, had retinal hemorrhages. Some of them had, I believe, extracranial trauma, if I'm remembering correctly. I haven't looked at the study in a little while. And for sure, there were some caregivers that confessed to shaking among the cases in that review. So yes, it's very unusual, but it's not without precedent, and it has been documented in other cases.
Very good. Also, with regard to the imaging, you indicated it was consistent with widespread anoxic, help me with that term.
Yeah, anoxic or hypoxic,
Anoxic injury is how you characterize it.
or I think, I haven't looked at the radiologist report. I think he was referring to hypoxic ischemic injury, or maybe it was anoxic injury. I don't remember the descriptor exactly. But it was having to do with what he was saying, I believe, was that on the imaging, the brain looked like it hadn't gotten enough oxygen.
Okay. Help the judge understand what the term of art as far as a cascade of injury, what that means, and maybe I can follow up with a question about, did you see that cascade here in Kaylin?
Well, I didn't see the cascade, but I think there's reason to believe the cascade probably took place in his brain, and what Mr. Coleman is referring to is you from perhaps severe acceleration, deceleration, with or without an impact, you get a brain injury, and there may be differential motion between the skull and the brain itself that results in shearing forces. You know, shear is something like this.
And for the record, so we're clear, you got your hand on top of the other hand, making a back and forth motion, almost like two plates moving back and forth. If you think of it in geological, earthquake type terms. I just wanted it to be clear on the record what you're doing, what motions you're.
Yes, sure. I'm sorry about that.
Yes.
And that shearing, may cause swelling of the tissues. And it may affect parts of the brain that control breathing. And breathing may become difficult or less than adequate, which means that you may not get enough oxygen through your lungs. And the brain swelling also may, when the brain swells, the skull doesn't give. So when the brain swells, pressure goes up, called increased intracranial pressure. And, there are blood vessels both going up into and coming back out of the brain. And that pressure may partially or even may occlude or block the blood vessels, and that's what's carrying the blood from the oxygen from the oxygen from the lungs to the brain is the blood. So if the blood flow gets compromised by the swelling, it's even more, or it's another factor to reduce the oxygen delivery to the brain tissue. So the injury is being compounded as the brain swells, and then as the nerve cells or as the cells in the brain start getting, some of them may have been sheared, some of them now are not getting enough oxygen. They release toxins that cause further injury. So that's what we're referring to with the cascade.
Cascade. In other words, neuron shear, there's swelling, leading to pressure, leading to reduced blood flow, which leads to reduced oxygen, which also leads to release of toxins. The compounding, as you put it, the cascade, as you put it.
And don't forget to include in there the fact that breathing may be affected either because of swelling involving the centers of the brain that help control breathing, or maybe even, there's some evidence that nerve roots in the neck that go to the diaphragm may get damaged as well. Anyway, for whatever reasons, breathing, like in Caitlin's case, whatever the exact mechanism that we got there by, we know from what we were told from physicians at St. Elizabeth's or medical personnel at St. Elizabeth's at Texas Children's, and from the CPS worker, and even from Caitlin's father himself, that he was having problems breathing by the time we got to 2 o'clock in the afternoon. So I'm sorry, but
No, that's quite right. As it results specifically to the cascade in Caitlin, you noted in your affidavit that there was shear indications of shear injury or injuries within the brain. That is to say, hypoxia or inadequate oxygen, ischemia, being diminished delivery of that oxygen through the blood vessels, apnea, meaning failure to breathe, brain swelling, meaning increased pressure on the skull to compromise the blood flow, and lastly, oh, you're gonna have to help me with this.
Excitotoxicity.
Give it to me one more time.
Excitotoxicity, I can hardly say it.
Yeah, which means the release of cellular toxins triggered by the brain damage. Those are the cascade or the cascade specific to Kaylin in this particular case.
Yeah, let me just, to be totally transparent, we don't have, what we saw in the imaging was the swelling. We don't have direct evidence of shear, but we do know that both linear acceleration and angular or rotational acceleration may give you that differential motion of the brain and the skull to give you shear. So we don't have direct evidence of that on imaging or anything, but shear occurs with those kinds of forces on the brain.
Okay. Confession. And you were present during this exchange with counsel for the applicant and the witness, previous witness about I think it was Dr. Lindbergh about what constitutes a confession or not. I am not asking you this question in a legal sense. What constitutes a valid or invalid confession? I'm only asking you this question as it relates to your opinion. We talked about the admission of the door frame strike, the admission of shaking in a resuscitative attempt. Would you, again, in your colloquial opinion, characterize that as a confession?
I'm not an expert on confessions, and although my daughter is a lawyer, I'm anything but a lawyer. So as far as I'm concerned, when I'm talking about confessions of caregivers and abusive injuries, whether it's, you know, abusive head trauma or something else, when I say confession, I'm talking about an admission of what was done, not talking about, you know, I understand that in the legal realm, there's a different definition of confession. That's not what I'm talking about or have been talking about in the past. It's an admission of what a person may have done.
And you're certainly not addressing whether or not someone was coerced or not coerced or to give that admission. You're not talking about whether or not they were given the Miranda rights or not give or properly waived the Miranda rights. You're not getting into any of that. You're just
No, sir.
making a determination, an assessment of whether or not an admission was made, right?
Yes, sir, that's correct.
And has that been a subject or topic that's been the subject of any research that you've done?
Yes, sir.
Can briefly explain to the judge. I mean, I think we've had our fair share of research studies in this trial. I just want to, I think this is
Yes, we
important.
have.
Yeah, I just want to make sure, I think this is important. I want the judge to understand that you've done research in this area. I suspect Mr. Udashian will address this as well. Briefly, what have you done and what were your conclusions?
Yes, I'll try not to bore you too much. We did, I say we, I and three colleagues, one of whom is a statistician and the other two were pediatricians. We published in 2020 what's called a systematic review. We titled it Some effective confessions and what do confessions reveal about abusive head trauma. And a systematic review, again, I'll try to be brief, but there are criteria, internationally agreed upon criteria for how to do a systematic review. You do, you set out a plan and you decide on inclusion and exclusion criteria for papers. For example, you might decide to exclude commentaries and letters to the editors, which are things that are published. And then you devise a search strategy. We used a medical librarian to help us with our search strategy, or really to devise it. And you go to a database.
Let me do this, Dr. Edwards. I appreciate the detail.
Yeah,
I really don't
sorry.
need to get deep in the weeds. Tell me whether or not you followed the applicable guidelines and
Yeah.
what was the purpose? What was the goal of this research?
Well, just what was in the title. We wanted to find out what confessions, that's our term for admissions, told us about abusive head trauma. So
And when we talk about confessions, you're talking about individuals who were suspected of inflicting serious shaken baby syndrome or abusive head trauma. And whether or not in the context of those allegations, they can subsequently confess. Am I making it, am I oversimplifying it?
No, I think that's accurate. There were cases in which there was a diagnosis of abusive head trauma in a child, and in which a caregiver had admitted to a mechanism of injury. And they may have admitted to more things than that. Some of them did, but those were our inclusion criteria, some of our inclusion criteria. And we ended up with 434 confessions from 55 studies, from 15 different countries, from 4 continents.
And what were you looking for? Were you looking for corroboration as to, you tell me, what were you looking for?
We were looking to find what information was available from looking at admissions of shaking by caregivers and children who were diagnosed with abusive head trauma.
And what did you find?
Well, there were 4 key features to our study. The first one is that shaking alone is the most commonly described mechanism. 64% of our admissions or confessions involve shaking alone. And then impact alone involved 18%. And the combination of the two, shaking and impact both, were admitted in 17% of those confessions. So that was number one, that those are the 3 main mechanisms that we found. There were a couple of crush injuries, there were no penetrating traumas, but it was those, I think 99% of the confessions were those 3. Of those 3, shaking alone turned out to be nearly 2/3 of them. And if you put together shaking and shaking with impact, it accounted for 82% of the confessions. The second key point was that this pattern was replicated in across all those 15 countries and those 4 continents, that the approximately 64% of confessions being shaking alone. The third key point, we looked at where the confession was or the admission was obtained. And we had 3 buckets. One bucket was during the medical evaluation, was the admission offered to medical providers. Second bucket was during the judicial / investigative process. And we lumped those together because it's different in different countries. Like in Europe, and I can't explain it because I don't know that much about it, but the investigation is done investigation is part of judicial process. So that was the second bucket. The third bucket was indeterminate, where it wasn't reported the circumstances in which the confession.
And Dr. Edwards, I'm sorry to interrupt. If I were sitting where Mr. Udashian was sitting, I'd be getting ready to object to your kind of narrative response. Let's just kind of cut to the chase.
Okay.
Please, sir.
Okay, sorry.
No.
I need to tell the judge why we did that, if that's all right. We are medical providers ourselves, and we know that when we take a medical history, when we interview, we don't use coercive techniques in medical interviewing. And there's no plea bargaining going on in medical interviewing. I know others will suggest that we're suggesting things for people to say, and I can't say that that never occurs, but that's not the practice that should be going on in medical interviewing. So we felt that there was little, if any, of that kind of biasing factor in the medical process, although we couldn't rule it out in the investigative process. And we figured if that was going on in the investigative process, you'd see more admissions of shaking alone or even shaking combined with impact in the investigative process.
And so again, the takeaway or the long and short of it is your study as it relates to confessions regarding individuals accused of, well, in instances where there's been an actual diagnosis of shaken baby syndrome or abusive head trauma, that study done by you and your cohort in your cohorts substantiated or corroborate that your findings as it relates to shaking alone can cause shaken baby syndrome or abusive head trauma. Is that fair to say?
I think it provided evidence for that. And I want to go back and say that we did statistical analysis on that we had 4 more confessions under investigation than we did under medical evaluation, but we had enough numbers to be able to look at it with statistical significance. And there was no statistically significant difference between the percentage of admissions, confessions of shaking alone in the medical evaluation than in the judicial investigative evaluation.
All right, it's fair to say this information, your study was published back in 2020.
It was.
Was it published in such a manner as to whether or not there could have either been a peer review or commentaries submitted?
Absolutely.
And you're a big boy. You're not without. You've been criticized before, and has this study been criticized?
Yes.
And you touched on some of the criticisms, the fact that it may be biased because some of those confessions or admissions may be as the result of a product of coercion, right?
You know, we don't know that, but could be a possibility, sure. And some of the admissions or confessions may have been false. We don't know that, and we had no way of validating, whether confessions were false or not. I think it strains, at least my belief, credibility to think that, that's one of the reasons we did a systematic review of literature from all over the world. We wanted to find as many, we wanted to cast a wide net, find as many confessions as we could. I'm sure, well, I'm not sure, but I suspect some of them are false, but I don't think all of them are.
And another criticism is that some of these confessions are the result of the offer of a plea bargain. That they wouldn't ordinarily confess to this offense, but because of the plea bargain that was extended or offer that was made, they chose to confess. Is that another criticism?
Sure. But again, that's why we tried to make sure we had, where we could identify where the confession took place. And, again, I don't have the legal background, but I know that some countries in Europe, there is no plea bargaining. So plea bargaining would not have been a factor in some of those situations.
And as the judge has indicated, what's most important to her is how does all this relate to this case? And so my question is, it relates to this case, correct, in the fact that we have what you would consider to be an admission from the defendant, Luther Garner, in this case, correct?
Well, no. I think I would have come to the same conclusions about Kaylin Garner without any admission of shaking. I mean, it was clear with no history of trauma. It was clear to me with no history of trauma, and the injuries that he had, I didn't feel that I needed, the admission of shaking, to come to that conclusion.
Yeah.
On the other hand, I would offer that I believe our study, it doesn't prove anything, but I think it provides pretty strong evidence that shaking, and it's one line of evidence, that shaking and maybe shaking alone can cause these injuries that we see in abusive head trauma.
And I get that you didn't need it to make your determination, but you understand that the admission in this case, or quote unquote confession, that is a component in this particular case and could be considered corroborating evidence.
That's probably a fair statement.
All right, very good. And a couple other things and I'll move on. Back in February of this year, you and I got invited to a get together with Mr. Udashian in Austin, and we got there and he called it a deposition. And we spent the better part of the morning there, and he focused a lot on this subject matter, this topic, correct?
Yeah, we spent about 3 hours, and a very large part of that was talking about confessions.
Yeah, and during the deposition, he admitted your report, and at this time, I'd like to mark it and admit your report on confessions that was previously admitted by Mr. Udashian at the deposition.
No objection to that, Your Honor.
So you've marked it as
State Board.
States Force admitted.
During the deposition, Mr. Udashian also used the Molina study. That's essentially by summary, it uses those, at least in part, the arguments about coercion and plea bargaining to attack your study, your work here in the confession study, correct?
That's correct.
All right, and I'm not gonna go into that. I'll leave that to Mr. Udashian. Sure, he'll take care of that. At this time, Judge, I'll mark what's entitled a review of blunt force injury homicides in children age 0 to 5 years in Bexar County, Texas, from 1988 to 2009, authored by Dr. Kimberly Molina et al., published, it looks like, in 2012 in the Forensic Medical AM Forensic Medical Pathology.
I have no objection to it, Your Honor. I think that's right, forensic medical pathology.
I think there's more to it. Looks like it's abbreviated, but that
Close enough for our
close.
purpose.
Close enough. All right, I'm marking it States 5, Judge, and I'll offer it.
States 5 is admitted.
All right, that's all I have on that. Doc, I'm gonna move on. Let's see. Briefly, let's talk about the triad. The judge has heard a lot about that. Just real quick, your take on this, the business of the triad.
And just because the Dr. Downs talked about, there's now been 2 different triads.
The diagnostic.
If you'll make it clear which triad you're talking about.
Yes, ma'am. Dr. Edwards, are you familiar with it? Would you use the term, or would you even differentiate between the triad or so-called triad and a diagnostic triad?
No, I think diagnostic triad is a term that I would not use. And the only time that it medically related that I use the term triad is like this in court, or in trying to respond to there are some physicians who assert that this triad of subdural hematoma, retinal hemorrhaging, and altered level of consciousness is used to diagnose abusive head trauma, or is used to is used to infer that shaking has taken place. That is what I consider to be a straw man argument. A straw man argument is one that mischaracterizes the argument. It's an argument against a straw man, not the real man. And that's what I consider these arguments about triad to be. Um, Physicians don't use the triad to diagnose shaking. Um, First of all-
Actual clinicians, the people who do this on a day-to-day basis, is that what you're referring to?
Right, right. Doctors who are caring for abused children don't use this so-called triad to infer shaking, and they don't use it to diagnose shaking. Shaking is not a diagnosis. And that's one of the problems with the term shaken baby syndrome. Because shaking is something that you do. It's a mechanism, but it's not a diagnosis. And that's one of the reasons, despite what's been said otherwise, that the Academy of Christian and Block in 2009 recommended use of the term abusive head trauma, which may have some problems too, but it at least doesn't imply a single mechanism, which was, the implication from shaken baby syndrome.
Very good. If we could move on to the biomechanical, you also refute the biomechanical studies as well. Again, this has been ground, it's been plowed by at least two, maybe all three of my previous witnesses. I don't want to spend a lot of time on that. What I'd like to ask you to address is maybe the injury threshold, as you understand it, and its implication with biomechanical studies and or the Coates study as it applies to the mechanical studies. Now, for the courts, just to remind the court, I think the Coates study is already in evidence through opposing counsel.
Sure. I think biofidelity as a limitation for biomechanical studies has already been hashed and rehashed. Tissue injury threshold may have been mentioned, but I think it's worthy of some consideration. An injury threshold is the level at which an injury will be induced. And the biomechanical studies use tissue injury thresholds to decide whether or not, an injury would be predicted under certain circumstances. I mean, really, to do that, you have to know the injury threshold. I think everybody understands that you can't directly measure injury thresholds in children. If you did, you'd probably end up before this judge. So where do these injury thresholds that they cite for children come from? The answer to that question, they take injury threshold. I think most of them come from subhuman primates, but some come from cadaveric tissue, dead people. Some come from data from adult volunteers like football players that I think Dr. Glasnick talked about instrumenting. But anyway, the way you get the tissue injury threshold on a child is take these injury thresholds from other living organisms and mathematically scale them down from a big brain to a little brain. And that's all you do is it's scaling based on size. And so that makes a lot of assumptions that aren't necessarily correct. For example, an adult brain or an adult primate's brain is going to have different anatomy. It's going to have different water content. The myelinization is going to be different. So the ability to really have validated and known confidently known injury threshold for children, particularly infants, it's not very good.
Fair enough. Now, what I'd like to do, and one last thing on that, and that's specific to the code study from 2017. There is a flaw in there that you want the court to know as it relates to anesthetization of animals.
Yeah, Coates and her colleagues pointed this out. And I think it's important. And it's true not only of her study, but all of the animal studies, that all of those animals are anesthetized. Because you couldn't get your study past the I or B if you were just pounding or shaking the head of a live animal that was conscious. Coates pointed out, I'm paraphrasing, that, there's reason to believe that shaking is done on many babies when crying is taking place. And that's true, that's been shown. That's a finding that we had in our study, but a number of other studies have identified crying as a trigger for shaking babies. And Coates pointed out that crying may affect cerebral, see, I can't talk here, cerebral blood flow to the brain. And that the anesthetized animal can't cry, and that may affect results. So that's just something to keep in mind. I think that's important. And something else that I'd really like to say about the Coates study, they explicitly stated the aim of the study, which is good and really should be done with just about any study. What are you trying to accomplish? They should explicitly state that, so you can see, the reader can evaluate, did they achieve their aim? And Coates said their objective was to exclude, no, that was, I'm sorry, I'm looking at the wrong one. Our objective was to examine the injury response of the young brain to single and repeated rotations. That's in the immature animals, the piglets. And she goes on to say, not to prove or disprove whether shaking alone can cause serious injury in human infants. And I'm just quoting Coates et al. In the piglet study that we read last night.
All right, very good. I'd like to shift gears, move on to, and I think the judge will appreciate this, the quote unquote new science as we've been tasked by the Court of Criminal Appeals to examine. In other words, to bring this back to all back to why we're here, whether or not the new theory or mechanism of either lucid intervals, illness that mimics the shaken baby syndrome, or shortfalls, or in other words, minor injury. Or minor injury that leads to the secondary injury of shaken baby or something that mimics shaken baby. I preface that, I say that by saying, when we're talking about all of those things, I just want you, the judges heard about shortfalls, the lucid intervals, other illnesses that may mimic shaken baby. I want to get at the heart, if we can, through this question or series of questions, what the Court of Criminal Appeals has tasked us to do. Whether or not had this information, was it available out there, at least in concept, in some form, to be brought before the jury if counsel chose to? And secondly, had it been brought before this jury, would it, or brought into that case, would it have affected either the testimony given by Dr. Stein or Dr. Moore, or maybe even ultimately, would there not be enough other corroboration for a jury, perhaps, to make?
And Your Honor,
I know.
I'm gonna have to object to that because he's asking him to respond to the question that the court is to respond to, not him.
Yeah, I mean, I guess Well, so far, I don't know that there's been a question.
Yeah.
There's been a statement as to what my task is. So let's get to what the question is, and then if there's an objection, we can take care of it.
I know it's a long setup, Judge. I mean, you understand we're here essentially, at least by and large, about the quote unquote new science, right?
Right,
The new science, including, whether or not these minor injuries, some of them maybe shortfalls, or lucid intervals, or injuries illnesses that mimic short shaken baby. That new science, whether or not it would have been available. Let's start there. Would it have, at least in conceptual form, not maybe word for word, letter for letter, but at least the idea, the notion of some alternative, as Dr. Glasny put it, some alternative uh, mechanism. Would that concept have been, at least in the early 2000s, available if someone chose to bring that concept for the jury?
yes. Um, there's a person that I think Dr. Glasnick, used to collaborate with, Dr. Patrick Barnes, that wrote extensively about alternative explanations of what was called shaken baby syndrome back then. And um, that was all available. Well, much of what Dr. Barnes had written in this regard was available in 2004, right? Uh, lucid intervals, we've been talking about lucid intervals, and they can exist uh, under sometimes. We've been talking about them for, I'm going to say 25, 30 years. What else?
Mimicking illnesses that
Oh,
may mimic the symptoms or signs of shaken baby.
absolutely. We've been talking about uh, uh, potential mimics like clitoric aciduria is a metabolic disease that we now screen for with the newborn screening in Texas. But that's was considered a mimic that has been around for a very long time, probably as long as we've recognized the problem of abusive head trauma going back to John Cathy. Well, earlier than that, I think Dr. Downs made a very good point that Dr. Tardieu in France recognized some of the things that we didn't rediscover until Dr. Kemp and others brought it forth. Anyway, I'm going down tangent. I'm sorry.
Thank you, Dr. Edwards. So again, just to put a fine point on that, I mean, while we're casting it and it's been cast as quote unquote new science, what we're really talking about is a new theory or hypothesis of a mechanism leading to the generally accepted science of the diagnosis of shaken baby syndrome or abusive head trauma in infants. Would you agree with that characterization?
I think so. I mean, I've been involved with working with child abuse for 20 plus years. And I'm so happy to say that during that time, there's been a lot of stuff done that that's made a difference, and we've learned more, and so there is new science, no question about that. But I'm not aware of any new science that alters our basic understanding and basic and or conceptual understanding of abusive head trauma.
Very good. I will conclude that particular portion of my outline by just simply asking, you've heard the testimony of Dr. Dr. Lindberg as it relates to this topic, the new science shortfall and that kind of thing. Do you agree or disagree with it? Is there anything you want to add before I move on?
No, I agree, and Dr. Lindberg knows a lot more about the new science than I do.
Very good. Now, while we talked about all of the things in the case material that you reviewed, imaging, CT scan imaging, the medical reports from the two different hospitals or the medical records from the two different hospitals. You did in fact review the reports of Dr. Fernando Stein and Dr. Patricia Moore, right?
You know, I'll be honest, there's a lot of material there. I read their testimony.
Okay.
I'm not sure that I've read their reports. Or I may have seen their reports, but I may not have paid enough attention.
You know, thanks for correcting me. I think I may be misspeaking. I think a lot of what I have in my notes may have actually come from the trial testimony as well. So, but nevertheless, there was material in all of those many documents reflecting the opinion or opinions, whether through testimony or through some other documents of opinion or opinions of Dr. Fernando Stein and Patricia Moore. Is that fair to say?
I believe so.
And the conclusion of Dr. Stein that there was some violent shaking of the body of Kaylin's body with interior or posterior movement of the head, resulting in multiple or repeated times, causing the brain to shear the neurons and get swelling and bleeding to the eyes or behind the eyes. Would you agree or disagree with that?
I think that's a fair statement.
You understand that Dr. Stein, at least at the time, was a pediatrician with Texas Children's Hospital who worked in the IC unit with about 25 years of experience. You have no reason to doubt that, do you?
No, I have no reason.
Okay. With regard to Patricia Moore, my notes indicate that at least at some point, either through her testimony or through some written documentation in the file, she indicated that some type of direct force to the head of Kaylin, whether it be a shaking mechanism or not, was involved, and that this type of mechanism was of an acceleration type injury that caused the problems to the brain and the eyes. Would you agree or disagree with that?
I would agree. That's a fair statement.
When asked, Dr. Moore, when asked at trial if this would have had an immediate effect on Kaylin, her answer was yes. And I think, would you agree with that or disagree with that?
I would agree with that.
And I think this goes straight to the heart of the lucid intervals discussion that we've been, or issue that we've been touching upon. Anything you want to add about the lucid interval, at least as it applies to Kaylin or this case?
I've had some clinical experience with brain swelling or cerebral edema, near drowning in particular, so not just with abusive head trauma. And certainly my experience over the years of practice that I've had, that brain swelling is not something that in which you will encounter a lucid interval. Lucid intervals do exist, but especially with brain swelling in general, but especially, there are degrees of brain swelling, and on a scale of 1 to 10, this is, to be a 10, I guess you'd need to herniate. Have the swelling so bad that the brain tissue starts going through the hole in the skull that lets the spinal cord go up into the brain. That'd be a 10. This appears to be, 9, 8.5, 9, something like that. I mean, I'm being arbitrary, but this was bad. So I really don't think that you would see a lucid interval with this kind of brain swelling. I might add that when I reviewed Dr. Golaznik's affidavit.
Are you making reference to the Bayard study?
Yes, sir.
Oh, please continue.
One of his references is by Bayard et al. Dr. Bayard is from Australia, I know, and that study described anesthetized sheep. They weren't lambs, in which they used a device that they could control the amount of velocity and so on to induce head injuries in these sheep. And they noted that changes in blood flow to the brain and brain oxygenation, I believe, was very early, almost immediate after the injury. And so and they went on to say that they felt that their results was constituted strong evidence against a lucid interval. Um, uh, Now, of course, Kalen Gorner did not have that kind of severe impact that they induced on those sheep, but that severe impact did um, induce brain swelling. So I would offer that even among Dr. Glasnick's references, there's one that calls into question the existence of lucid interval with brain swelling.
And just to bring it back around, and as a reminder for the judge, reason why it's important in this particular case is because of the allegation that perhaps mom, before she left for work that day, could have injured Kaylin, and because of that lucid interval, uh, while being left under the sole care of the defendant, it would appear that the defendant was responsible for what the actions of what mom actually committed. Is that fair to
Yes,
say?
that's fair to say. Dr. Christine Duhame, a neurosurgeon, um, has been referred to extensively, well, a number of times during the proceedings that I've heard. And I would just like to quote Dr. Duhame very briefly. She has written, "An alert, well-appearing child has not already suffered a devastating acute injury that will become clinically obvious hours to days later."
All right, I think I kind of want to wrap it up here, Dr. Edwards, with just a few more concluding questions here. And I'll ask these questions in this way so we can kind of get through it real quickly. You heard the testimony of Dr. Yu and Dr. Lindbergh as it relates to the studies and how they're not all created equal. Case studies, clinical research studies, and the type. Is there anything you want to add or anything that you would disagree with as it relates to their testimony?
I'll add one thing. Among the 6 studies that we read last night, well, excuse me, among the 6 articles we read last night, one is not a study at all. It's just an opinion piece with footnotes. And I thought it important to at least identify that's really not a study. It's that matches paper that we read.
Now, you've heard Dr. Yu and Dr. Lindbergh's testimony as it relates to biomechanical modeling. Is there anything that you either agree, do you agree or disagree with their testimony, or is there anything you want to add to that?
I really don't recall anything to which I would disagree. I would like to just add briefly, biomechanics is a field that is recognized, and it's important, and good people, a lot of good people are involved in it. And it has done a lot of good for mankind, and car safety, product safety, all kinds of and they help with accident reconstruction. So it's I don't want to criticize the discipline per se, and I think most, not all of the biomechanical engineers, but I think most of them, like Dr. Coates was quoting earlier, recognize the limitations. One of the reasons there's so many different models in the crash test dummy area is they're looking for the best model and they haven't found it yet. They recognize that they're not there yet. I guess just want to emphasize that they're doing good work, but we need to be very careful about extrapolating. They're doing scientific work, but we need to be careful about extrapolating and using it to predict or not to predict injury in real living children. One of the things is that if we use that, if we extrapolate from that work to suggest that certain actions won't necessarily injure a child, which in my humble opinion are very dangerous to children, we will give an impression that will, in my judgment, increase the risk of injury to children.
Thank you, Dr. Edwards. Let's move on. I'm going back through my outline to make sure there was something that there wasn't anything that I missed. And it appears that we missed the Atkinson study. I promise, Judge, I think this is the last one for sure.
I'll be brief.
Hold on a second. Let me ask, Mr. Udesha, is the Atkinson study already there? Did you put it in?
It's in it?
It's in.
I believe so, Your Honor, I believe it went in as number 8.
It's
If
one
it's
of the
not
studies
in-
we read,
if
but
it's
it's
not
not.
in, I'd like to put it in. It's-
I think that it was number 8.
I feel like that sounds right, but let me,
I don't want to be redundant. If it's already in, if you don't mind, I'll put it in,
just give me a minute.
Okay.
It's at least marked as number 8 on my list here. Here it is. Got it. It's
It's in.
in.
Remember during our prep, Dr. Edwards, bullet points, that's what we're talking about.
Yeah.
First bullet point, occipital falls, as it would relate to this particular case. The occipital falls that are mentioned in the research in that study and how it would potentially relate to this particular case.
The study doesn't relate, I think this has already been discussed, the study doesn't relate to this case because Kaylin was immobile. And to have an occipital fall, very, very difficult. The Atkinson study, the patients were aged 7 months to 16 months. They were all mobile.
Occipital meaning, and just as a reminder.
Back of the head.
Falling on the back of the head.
And what I take away from that study that I don't think has been mentioned is that there is a particular type of fall, this occipital fall, where you fall backwards, that in some ways is different from the common household falls that we all have agreed are almost all but benign. And what's different about these falls is angular or rotational acceleration. All these children were either sitting or standing when they fell. And the one that died was pushed when he or she fell. So, this is a particular type of fall. And we already know that from biomechanical work with the crash test dummies, that that angular acceleration alone is not as bad as angular acceleration with impact. So in most uncomplicated falls, you've got linear acceleration. If a baby falls off the couch, it's a linear movement to the ground, and he gets a linear impact. If a baby or if a toddler, I should say, falls backwards from sitting or standing or whatever, it's not linear down, it's rotational down, and there's reason to believe that makes it worse. And then furthermore, a backward fall is much harder, you know, even if you're young, if you fall, you got that, I think they call it the parachute reflex, you're gonna, in many, if not most cases, try to break the fall. When you fall backwards, it's hard as hell to break the fall because your arms don't work as well that way. So these child abuse pediatricians indicated that a type of fall that's different that we need to be on the alert for. You know, I think I give these guys credit for revealing a particular type of fall. And you can't generalize to all falls because these falls, I'm not going to say they're unique, but they're different. Um,
Fair enough, Dr. Edwards. If we could move on, please.
Yes, sir.
I'd like to focus on the testimony of Dr. Glasnick and a couple of points during his testimony. One point being there needs to be a broken neck, rib fracture, or some type of ligament damage that accompanies shaken baby syndrome or abusive victim. What's your take on that, sir?
Well, we know that there are many kids that have abusive head trauma that don't get rib fractures. Uh, uh, and that's pretty cut and dry themselves. We've got kids with abusive head trauma with metaphyseal fractures, but no rib fractures. You know, so rib fractures are a frequent accompaniment, but they don't have to be there. Now, with regard to the neck, one of the new science developments since I've been practicing is, and Dr. Lindbergh referred to this, the improvements in MRI technology. Like Caitlin didn't get an MRI because I don't think he was ever off a ventilator. And you know, the MRI is a big old magnet and it'll, anything metal, you're gonna have a bad scene in the MRI. So you can't take a patient in a ventilator and MRI. The reason we don't have an MRI on Caitlin, I believe, was because they couldn't do it because he was on a ventilator. And it's been pointed out that Caitlin didn't have a neck injury. I would offer that we don't know whether he had a neck injury because he never had an MRI. He never really had any study that would demonstrate whether or not he had a neck injury. And he couldn't tell us whether his neck hurt, you know?
Speaking of an MRI, Dr. Edwards, that leads me to the next portion of Dr. Glasnick's testimony, and that was with regard to the transverse sinus thrombosis and the image, the CT image related to that. No, I'm mixing it up with the edema. Am I thinking of the image? What was that image, the CT image, supposed to purportedly represent?
They talked about epidural hematoma
Epidural
and transverse sinus thrombosis.
being one being a primary cause and then the other one being the
That
secondary.
would suggest it.
Yeah. And then here's my question, because I think it dovetails into the from the MRI is that I mean, looking at that scan, first of all, that scan is, or those two images of a scan, you refer to them as cuts. Why do you refer to them that way?
Well, because you know, they are sequential sections through the brain, and you know, maybe that's not the best terminology, but it's like parallel slicing in an orange or something. So yeah, those are two cuts that I saw, two cuts of the MRI, and it is true that there's pretty clearly a small density. It's bright. You saw it bright on the MRI. I mean, on the CT, and it's almost certainly blood. And it was characterized as an epidural hematoma. I think there's already been discussion that the dura is between the brain and the skull, and epidural blood is on the skull side of the dura, and subdural blood is on the brain side of the dura. Well, I'm no radiologist, but I've spent a lot of time with radiologists, and I've spent a lot of time with neuroradiologists looking at studies, and I can affirm to you that at least in children, and this may not be true for adults, I don't do adults, so I'm not gonna comment on that. But for children, it is very difficult to say definitively whether blood is in the epidural space or the subdural space on CT. Now, an epidural bleed will tend to have a lenticular shape. And one of those cuts, there's no question, it's got a convex curve and the shape suggests epidural. Now, what I saw on the other cut was a much of that brightness was a much more concave appearance, which is much more typical of subdural. I honestly don't know whether that blood is epidural or subdural.
Which brings me to my next question. No, I'm sorry to interrupt. Go right and finish that thought.
No, it could be either one.
Which brings me to my next question, two-part question. One, would it be more beneficial to see the entirety of the scan as opposed to just two cuts?
Always.
All right, and the second part of that question is, would it be more beneficial for a neuroradiologist to take a look at it? And give us their
A pediatric neuroradiologist.
determination?
I don't wanna, I'm not criticizing adult neuroradiologists because they study adults. But I was recently talking with one of my pediatric radiology colleagues in Austin. And she's not a neuroradiologist, she's a pediatric radiologist. But she was saying, in her experience, that adult general neuroradiologists really miss a lot of things in children. So yes, you're right. The best evaluation of head imaging is done by pediatric neuroradiologists, head imaging of children.
And as it relates to the transverse sinus thrombosis, there is a study that's already in evidence. It's a court for the Court of Criminal Appeals wants to review that study. For whatever reason, it's in evidence already. Is that fair to say?
I believe so.
Yes. All right. Your affidavit that you submitted, that's a fair summary of your account, your testimony here today.
Yes, sir, it is.
All right, let's get this out of the way. You're being paid for your services as an expert witness here today at a rate of $200 per hour, correct?
That is correct.
Plus your expenses.
Yes, sir.
Has that in any way influenced your testimony today?
No, sir.
Do you have a personal stake, or you a close family member have a personal stake in the outcome of this trial?
No, sir.
In fact, you disclosed or said as much in your signed non-disclosure statement, correct?
That is correct.
I will conclude with these last three questions, one of which was really important to you. You wanted me to make sure that I ask this: Are people accused of or convicted of child abuse? Are they bad people?
No, they're not. Most child abuse is impulsive. It's not premeditated. And I'm going to quote another child abuse pediatrician, Dr. Steve Boose, I believe, who said this. Child abusers are not monsters. They're people who've had a monstrous moment. So caregivers and parents, particularly young and inexperienced ones, they need more support in our society, and they need better education, and they need more sympathy, if you will. And now, for when a monstrous moment does take place, I guess the question arises: what's the appropriate accountability?
And I get that, Dr.
Yeah,
Edwards,
let's-
but this is not the proper
Yeah.
form or proceeding for that.
Okay.
I just was giving you a little bit of deference there by asking the question that you want me to ask. Two more questions. In your affidavit, you put that over a dozen multinational professional medical societies have confirmed the validity of the diagnosis of shaken baby syndrome or abusive head trauma in infants. True, correct? That's what's
Absolutely.
in your affidavit. And lastly, the theory or the science behind the diagnosis of shaken baby syndrome or abusive head trauma in infants remains generally accepted by physicians who frequently encounter suspected child abuse. Is that true or not true?
That is true, sir.
Dr. Edwards, I appreciate your time. Thank you for being here. That is all of the questions I have for now. I'll pass it over to Judge.
Thank you, Mr. Coleman. All right, let's take just a 10-minute break. It's about 5 after. Well, a little more than that. We'll get started by 3:20. Take about 10 minutes. Court's in recess. All right, we're back on the record. State's attorneys are here, applicants' attorneys. Mr. Garner's here. Mr. Udishin, you may proceed.
Thank you, Your Honor. Dr. Edwards, let me start with what I think is an easy concept, is that if you accept the biomechanical engineering studies concerning shaking alone, if you accept those, then there is just simply no question that there's new science on the shaking theory. Would you agree with that?
I think so. What do you mean? What do you mean by accept? Accept that they are.
Well, that's good. That was too vague. Let me tell you what I mean. Let me rephrase it.
Okay.
What I mean by accept is that you accept that they are engaging in a legitimate scientific process in performing those studies and issuing those reports.
When they're done in good faith, and I think most of them are. I agree.
So the issue about biomechanical engineering in your view is not whether it's a legitimate area of science. I mean, you agree that it is, right?
I've done that, yes. I've already done that.
And they do a lot of work in a lot of different areas that you certainly have no qualms about following their recommendations.
Yeah.
Okay, so is the only area that you're aware of where biomechanical engineers have done research and issued reports that you have any question about is in this area of shaking?
That's an interesting question. You know, I don't have a problem with the work of Oates or Margulies or Prang or Corey and Jones, etc. I don't have a problem with their work. The problem I have is with the extrapolation, what I consider to be the inappropriate extrapolation of their work to human infants and children. And I think most of them would agree with me, because you will find, if you look, you don't even have to look carefully, you will find in most, maybe not all, but just like we found in Coates, statements recognizing the limitations of their work and warning, but they don't use the word warning, but let me use it, essentially warning us as the reader to be careful about using their work to predict injuries in human infants. So I don't have a problem with their work. I have a problem with the way some people extrapolate their work that I think they would agree with me. I shouldn't try to speak for them, but I do think at least most of them would agree with me it's inappropriate.
Okay, well, you are aware that at least 2 Supreme Courts in other states, New Jersey and Michigan, have said something to the effect of biomechanical engineers are really not qualified to critique the work of physicians, just like physicians are not qualified to critique the work of biomechanical engineers. Were you aware that those 2 Supreme Courts from those states have said that?
At least in a macro. I mean, I'm not familiar with the details of the cases, but yes, I've heard that. Yeah.
But isn't that, I mean, isn't that really what you're doing is you are a physician and you are critiquing the work of a whole different scientific field?
No, I am not critiquing their work. I am critiquing the extrapolation of their work. And I think that I'm in agreement with them. They don't want their, the ones I've read, I think Susan Margulies would not appreciate her work being extrapolated inappropriately, and likewise Brittany Coates.
Well, so and I didn't mean to interrupt you if I did,
Oh, that's all right.
but you're aware that Susan Margulies is one of the authors of what we all call the praying study, right?
Right.
And the praying study is the leading study that raises the questions about whether or not a person can shake a baby with sufficient force to cause the injuries we talk about in these cases. That Susan Margulies is one of the authors with Michael Prang on that study.
I'm aware of that.
And that their study has been used for that purpose because that is precisely what their study says. Nobody is making up words. They said that. Are you aware of that?
I'm not sure what words you are referring to that I'm supposed to understand, with all due respect, but may I quote from Prang et al., including Dr. Margulies, from their 2003 study?
If you, yeah, that's fine.
And I quote here, although the anthropomorphic test dummy data are useful regarding falls and inflicted injury events, the results cannot be used to predict injury. Regional tissue thresholds are required to predict injury, and they are unavailable for the pediatric population. That is from Prang et al. 2003.
And you know that the research in the biomechanical engineering world has continued. That was 13 years ago. You know they have continued to study and issue more reports in this area.
That's true pretty much across the board, isn't it?
And I mean, it's true in every
Yeah,
area.
sure. Yeah, you're right.
And you're aware that the very issue that you are raising and that the other states experts have raised, the very issue about whether or not this is legitimately applied to the situation of child head injuries, whether the biomechanical engineering studies are legitimately applied to the issue of childhood head injuries. You are aware that these very same arguments that y'all have been making here were specifically rejected by both the New Jersey and the Michigan Supreme Courts.
I can't comment on that.
Okay, but you know this. I mean, I know you're not saying you came up with these arguments. I mean, these arguments are out in the field, and people have been making these arguments for a while.
I don't know what other people have been doing. I know what the courts that you're referring to, I know a little something about what they've decided. I think you questioned whether, doctors should critique the work of biomechanical engineers. And I'm not really critiquing their work, at least not most of it. I wonder if it's analogous, whether lawyers, like say Dr. Finley, should be critiquing the work of physicians.
Well, and did you read Professor Finley's reports in this case?
I have seen Dr. Finley's report. It came in late, and yes, I have seen it, and I've read some of the work that he's written in the past.
And he's not, and I mean, tell me if you disagree with this.
Sure.
What Professor Finley is doing is summarizing the studies and the effect they have in the legal arena.
You asked me if I understood that that's what he was doing.
That is what I'm asking.
May I share then in response what I think he is doing?
Okay, sure. Go ahead and tell us.
I think he is appropriately concerned about overdiagnosis of abuse and is making probably very good faith efforts to remedy that. In so doing, this is a high stakes area, child abuse. And if you get it wrong, either way, overdiagnosis, underdiagnosis, you've got adverse effects that you want to avoid. And they're major adverse effects. If you overdiagnose it, you are disrupting families. It can lead to, in certain circumstances, to incarceration. If you don't get it right and you call it when it isn't really there, you're creating all kinds of problems. But if you underdiagnose it, you have a different set of problems. And you're putting children at risk for subsequent injury or even death. Now, I think what we need to do is get it right. Not underdiagnose, not overdiagnose. Now, my opinion of what Dr. Finley is trying to do is he's trying to lower it so that we miss, so that we have less overdiagnosis. But in so doing, I think what he is doing is putting us at risk for missing cases or having the folks that are by law charged with protecting children less aggressive. I think he may not realize, but in my opinion, he's causing some unintended consequences and potential unintended consequences that are unfortunate.
Am I causing some unintended consequences that
You're
are
doing your
unfortunate?
job.
Okay, so I mean,
You're doing your job and you're doing it well to advocate for your client, and I totally respect that. Dr. Finley is doing something else. So I don't, in no way, and I apologize if I sounded as if, I was directing that towards you. So my sincere apologies if that was the way it sounded.
okay, so when we're talking about really what you're raising is an interesting question because it's at the core of the American judicial system is about how do you protect the innocent people at the same time you convict the not innocent people. It's the core problem that we all deal with in the criminal justice system. But are you suggesting that we should make it easier to convict people
No.
of child abuse?
No, not at all. Not at all, sir.
Okay, so you know,
I'm position I'm trying to take is that we, with regard to child abuse, we need to get it right. Our discipline needs to look at ourselves. And I think, I have a colleague, Dr. Andrea Asnes.
Your Honor, I'm sorry, Doctor, to interrupt. I don't necessarily have an objection. I'm happy to listen to this back and forth, but I'm a little concerned about the hour and how much more information we gotta get through. But again, there is some objection. Maybe narrative,
I'll ask another
maybe
question.
narrative, maybe relevance, but I'm happy to let this go on if he wants to.
I think I agree with that.
I would completely agree with that
Okay.
because we're
All right, so Doctor, let me move on to the question about confessions. And like Mr. Coleman mentioned, we did a deposition in Austin in February where you and I discussed primarily confessions for about 3 hours.
It doesn't seem that short.
Okay. And Your Honor, just so you're clear, the deposition transcript has been filed with the court. So the court has the deposition transcript.
So knowing that, I would ask that with regard to certain points that you want to get out, let's go through that. But if you would, I mean, if I need to read that, I would be happy to.
Okay, well,
So that might help.
I will really ask just a couple of
Sure.
questions about it because obviously the court's gonna read the entire transcript. But in the course of the deposition, the discussion about confessions, of course, the reason why we wanted to have a deposition of you about confessions is that you have written, or you and some colleagues have compiled what is really the leading paper in the child abuse community concerning confessions in abusive head trauma. And I know you're humble, but that's the fact, isn't it?
You're very kind to say that. We have done the only systematic review. I don't know that it's the leading publication, but I think it's a significant, in my judgment, my humble judgment, it's a significant and meaningful contribution. And it is a systematic review, which is, you know, if randomized clinical trials are at the top of the toolkit that Dr. Lindbergh referred to, and case reports are down here at the bottom. Systematic reviews are on the upper side of.
Well, but just one of the points I'm getting to is you very freely said in the deposition, you are not an expert on confessions.
I think I said that earlier.
Right, so you don't claim to be an expert.
No,
on
I don't.
confessions. You are a physician. You gathered some material and put it in your paper, essentially. Is that right?
That's a little bit of an oversimplification, but yes.
But for the sake of time, let me
Sure.
oversimplify.
Sure.
Okay, so you did actually put into your paper, and we discussed this at length in the deposition, that by your own assessment, 82% of the data in your paper, and the data means the confessions you were using, that 82% of those confessions were what you characterized as low quality. That was your own calculation. Is that correct?
Dr. Edwards, are you looking for that?
Yes. Thank you,
Yes, sir.
Judge.
I'm here for it.
You're good.
If that's all it takes, I'll take it.
Okay. Do I need to give a yes or no?
If you would just give a yes or no, because I want to move through this quickly because the judge is going to read it. It is true that in your own paper, you characterized 82% of your data as low quality. Is that correct?
Not exactly, but if I can have a chance to come back to that, either with your permission or on redirect, I think
Well,
on the further answer.
It's in the deposition, so I won't beat it to death. The judge can read it.
I'm not sure all the data is in the deposition.
The paper's in evidence, so you can
Yes, it
rest
is.
assured the judge is going to read your paper.
All right.
And then she'll read the deposition. Okay, so you're aware that one of the questions that has been raised about your compilation of confessions is the use of resuscitative confessions, meaning a caregiver saying, I shook the baby or I shook my child because he wasn't breathing or he wasn't responding, and I shook him. To do that you included those among your confessions. That's correct, isn't it? Those were included.
Essentially, yes. Mhm.
And that really is like the confession or the admission we have here from Mr. Garner. I mean, Mr. Garner's statement, would it fit into that category?
I'm really not sure that it would.
Okay, and tell us why his statement wouldn't fit into the category of a caregiver saying, I shook my child because they weren't responding.
Well, I think, touched on that a little bit earlier. He, in terms of motivation for the shaking, what I read in the police report, there were two motivations. One was to make him respond. And I'm not sure if I would call that resuscitation. Trying to make somebody respond. I think calling that resuscitation is maybe going a little bit far. But I think more importantly, he expressed a second motivation, and that was to calm the child down. And, you know, which is true? Are they both true? I certainly don't know. Or are they both incorrect? I mean, I don't know. I'm not, to finally answer your question, I'm sorry, Judge, but to finally answer your question, I'm not sure that we should put what his statement in that category.
Okay, so now you read Dr. Stein's testimony at the trial, correct?
Yeah, some of it I read more carefully than others. There's a lot of it.
But you know from either reading it or from sitting in the courtroom for the last 3 days that Dr. Stein was basically read the statement that at least the part of Mr. Garner's statement about shaking, where he said what he did and why he did it. And he was asked, is that what we are talking about when you're talking about that this injury was caused by shaking? You recall that was a question to Dr. Stein.
Vaguely.
And his answer, he's very short and to the point. His answer was no. Do you recall that?
I'm not sure I recall that specifically, but I'll accept your.
Okay, well let me ask this question. If Dr. Stein said he did not consider Mr. Garner's confession to be his statement about shaking to be a confession or admission to the kind of shaking that he was describing that he believed was done to this child, would you disagree with his assessment of that?
I don't think I can really. I don't know what was in Dr. Stein's mind, quite honestly, and my recollection of the father's, Mr. Garner's description of the shaking that he said he did. I recall that he said that he shook him more times than he could count, but I don't think he made, or at least I don't recall any statement about any further about how that reported shaking was done.
So and I guess what you're getting at, he did not say he shook this child violently.
No, and he didn't. I think that's correct. And I don't think he said that he shook him gently.
Okay, so isn't it correct that the kind of shaking that is referred to or meant to be considered the kind of shaking that would cause the injuries in the shaken baby theory is very violent, repetitive shaking?
It's not a theory, but nonetheless, I I think there's 2 points that are important here. One is that the violent and repetitive, I think, as you know from our earlier discussion, largely comes from the Adams-Baum study in France, where there were, and I think anybody that is really interested in abusive head trauma should read that study, because there are rich accounts of people telling what they did when they shook. And the conclusion that Adams-Baum came from that was that shaking that causes injury is almost universally described as violent, and much of it, not all of it, but much of it is repetitive. Now, the second thing is that we know from accounts of witnessed shaking that many times witnessed shaking results in no injury. Shaking doesn't always result in injury. So it just, now some witness shaking, at least one.
And excuse me, I don't mean to cut you off, but I think the judge is gonna make me cut you off, so.
Well, I was trying to respond to your question.
Okay, okay, I'm sorry, go ahead and do that.
Yeah, well, I'm pretty much finished, I guess. There are clearly there are degrees of shaking, and some shaking doesn't leave apparent injuries, and some shaking causes death, or potentially causes death. And so let's leave it at that.
So are you saying that shaking that is less than violent can be the kind of shaking that would cause the injuries seen in the alleged shaken baby cases?
No, I don't think so.
Okay, so if a statement is made by Mr. Garner or any accused person that they shook their baby for whatever reason, but it doesn't say they shook them violently, would you agree that is not a confession to the shaken baby?
No, I don't think I would agree to that. If you've got a kid with significant injuries and no history of trauma, then that's strong indication that trauma that we don't know about has happened.
But that's not what we're talking about. We're
Yeah,
talking
it
about
is.
this, but I'm talking about the confession itself. You're talking about the whole case. I'm saying, and I'm going to move on from that. I just want to say one more thing about that, which is, do you agree with me that this is one of the issues that has been identified in your confession paper, is that you use this type of statement as a confession? That
Well,
other people have said, you shouldn't be doing that.
Well, let me just share some data with you. I think, as you know, we identified 434 cases. Now, we identified among those cases in which there was perpetrator motivation included in the admission. And it turned out that we had 49 of the 434 cases. We had a statement about perpetrator motivation, and the majority of those cases, the motivation was frustration or anger. But 30.6% of those 49 cases, which is 15 cases, the motivation was to resuscitate or revive. So, we did identify 15 cases that in which perpetrator motivation was to stop choking or resuscitate in some way from something. I will also say that, you know, if you've got a child with significant injuries, where did they come from? And if your history is they had an apparent life-threatening event, which is not going to cause injury, and then they were shaken, you've got reason to believe that the shaking is the most likely cause of their injuries. Because an apparent life-threatening.
And I'm sorry to cut you off, because I'm talking about confessions, but let me ask you a different question about confessions. You recall at the end of our deposition, we were discussing this Molina article concerning Bexar County, San Antonio. And I gave you a copy and I asked you to read it and to see if there was anything in there that would alter any of your assessment of confessions in this area. And I didn't hear anything, but so I want to know if you.
I'm sorry if you didn't hear anything. I'm pretty sure that I let Mr. Coleman know that I had reread it. In fact, I've reread it last night, but I did let Mr. Coleman know, and I don't know if he was able to communicate.
Well, that's fine. But you agree, since you've read it several times, that what this article is about, the issue is whether or not the reason why people, the reason why people confess to the police or even to medical personnel, but that the reason why people are confessing to the police is that the police are telling these people, the accused people, that the doctors said this child was shaken and you must have shaken them. There is no other explanation. And that is what's inducing people to say they shook the baby. You understand that was really one of the points of this article, was looking at that question in San Antonio, Texas, in Bexar County, because none of the confessions that were given in that entire large county were to shaking alone. You understand that that was what the facts were in this article.
I'm familiar with the facts of the article, but I would offer to you that I think the conclusions that you just went through go beyond what is supported by the facts.
So the conclusion, my conclusion doesn't matter. The conclusion of the doctors, the four doctors.
I think they went beyond what the facts.
So you're saying their conclusions were beyond what the facts supported?
That's my opinion.
Now, their conclusions were, just to be clear, what they said, and these are all doctors practicing in Bexar County. They said in Bexar County, their county, that the district attorney's office did not prosecute cases where the allegation was shaking alone, because the medical examiner in that county did not believe in that theory and would not support that. So the district attorney didn't prosecute cases under shaking alone, and that their conclusion was the entire system in Bexar County, including the police, knew that. So the police didn't have an incentive to say to suspects, the doctors say it's shaking alone, you might as well admit you shook. So they didn't do that, and therefore they got no confessions to shaking alone. That's what they said. Now, you may disagree with them, but you agree that's what these authors said.
Let's look at the data. They did a retrospective review of, from 1998 to 2009, and I don't think it matters how many deaths these are all autopsies, but they found, well, it was 101 deaths, children less than 6. 73 were related to head injury. Of those, they had 12 confessions. 10 confessions, I believe it was 10, had no shaking. I think they had 10 confessions with just impact, and they had 2 confessions with both shaking and impact. Now, those are the numbers. Um, uh, They, then, as you said, they asserted that the policy of the Bexar County Medical Examiner affected the incidence of shaking, that they attribute. That's a pretty big jump, that the policy affected the confessions. Now, as you say, that they think that's because the police changed their interrogation tactics because he wasn't using that diagnosis. Yeah, we did, we had about 55, no, not about, we had exactly 55 studies in our systematic review. This is one of either 2 or 3 that did not have uh, 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 shaking alone admissions. Let's remember these numbers from Bexar County, they're small. You know, they only had 12 confessions. One of the reasons we did the study is that there weren't, the systematic review was that there weren't case series that had a lot of confessions in them. And so we wanted to get numbers to try to get more reliable data. I think to wind up here, a small number of confessions, an assertion that's not based on data, but is based on some speculation. And that this is not unique. And I don't think it affects the conclusions of our systematic review, and certainly it doesn't, in my mind, affect my conclusions about this case of Kalen Gorham.
And I'm gonna just ask a few more questions, and I'm gonna wrap it up with you, Doctor, is that you actually agreed with me at the deposition that if the police say to a accused person, the doctor said the baby was shaken, that really taints the confession that they make if they say, okay, I shook the baby, and calls it into question as to whether it's a legitimate confession.
It might taint it. I mean, just because something was suggested and a person agrees with it, doesn't mean that the person is misrepresenting what happened. But I certainly will grant you that possibility that that's going to taint it exists. And as I can't remember for sure, but I think I told you at the deposition, you know, I don't think that's the right way to go about interviewing people.
It's not an appropriate way for the police to approach somebody in your view.
That was one of the reasons we wanted to look at, see if there was any difference between investigative results and results that came to medical attention.
But would it surprise you to learn that all, or at least virtually all confessions that people have made to the police of shaking alone are based upon an interrogation where the police say the doctor said the baby was shaken? That is the common procedure.
I don't know that. Is that the common procedure in Europe or Australia or New Zealand?
Well, do you have any reason to think the police there wouldn't do something that the police here would do?
You know, I don't know. Some countries don't have plea bargaining. You know, and videotaping is more common now. And I would hope that people would behave better if they're being videotaped. So I really don't know.
Okay, well, I understand. I'll pass the witness.
Thank you, Mr. Yudishin. Mr. Coleman?
I have nothing further for Dr. Edwards, Your Honor.
Wow. All right, doctor, you can step down.
Thank you. Thank you, Judge.
Your Honor, the state has no additional witnesses.
All right. Mr. Yudishin.
Well, so Judge, there's a couple of things that I want to bring up. I know we need to talk about scheduling a little bit, but one thing is that I believe it was yesterday when I was in the process of making an objection to the state getting into the other two children, the issue of the other two children in the questioning of their witnesses. And Mr. Coleman agreed that he was not going to do that. I took that, I want to make sure I took it in the correct way. I took that to mean that the state did not believe the court should consider that in making your findings of fact and conclusions of law. That's my first question.
Well, here's what I think the Court of Appeals is asking is not having, my understanding, and I'll tell you now, I did not intentionally, I did not go into the punishment phase when I read the transcript. So I actually have a very, other than what you all are saying about that, my job is to find beyond the preponderance of the evidence if the jury would have determined some different things. So it's guilt or innocence that I think my question relates to. And so I don't intend to take that into consideration or get it. Feel like I have enough on my notes here to read, that I don't intend to do that. Mr. Coleman?
I didn't want to get into it because quite simply, I just thought it would be problematic and it could very well be problematic at the next level. But what I don't want to do is somehow have some unintended concession or waiver that comes back to bite.
No, I'll tell y'all now, I don't think it is relevant to what I have been asked to determine.
And Judge, I agree with what the court is saying. This is the problem we have right now, is that it's not relevant. I understand the court's not going to consider it. In several of the states' doctors' affidavits, the witnesses who testified, they mentioned it. Okay, and I understand the court, you can ignore it and you're going to ignore it. But when it goes to the Court of Criminal Appeals, obviously, they're probably going to read those affidavits. What I was going to do yesterday, before Mr. Coleman said he wasn't going to pursue it, I was going to offer a couple of exhibits that relate to the question of the other children. It's a little awkward now for me to offer exhibits on something that the court has already said you're not going to consider, but I feel compelled to do it just to have it in the record, to go to the Court of Criminal Appeals in case they decide to consider it, because they're the ultimate finder of fact here.
And that's kind of my consideration, is that I don't want to do something at this level where it's a waiver or concession if the Court of Criminal Appeals is inclined to consider it, you know? I don't want to close the door, and I don't want somebody to say, well, the state abandoned it or waived it or conceded that it's not relevant or something like that. You know?
So I mean, what's going to happen is, I guess you're not going to consider it. And
I
then
mean, do y'all want me to consider?
no,
Okay.
no.
No,
But it's good.
I think it could be problematic, Judge, but you understand my position. I don't want to do something that at the next level,
So why don't we do this? Why don't you take a look, Mr. Coleman, at what Mr. Udison is proposing to enter into the record? And then if you don't have any objection to that information going to the Court of Criminal Appeals without me looking at it, then it can be admitted. I'll make a notation and I will not add it to my hundreds and hundreds of pages of information that apparently I'm going to be reading on a plane tomorrow morning.
So let me just.
I mean, I've seen this, I know.
Yeah. So just for Mr. Coleman's sake, I mean, obviously, the first one in Caitlin's renumbering them for us.
I
But-
believe we're on 15.
Okay, so what we have marked Defendant's Exhibit 15 is a letter from Mr. Alex Buey, a child professional, to Mr. Alex Buey at CPS from Dr. Luca. And it just sets out some information about the child that was mentioned in the punishment phase that we feel like indicates that Mr. Garner was not responsible for those injuries. And that's just a letter. That's
Okay.
one thing.
So do you want to?
All I want to do is put
I
it in
don't,
record.
I mean, you're kind of telling me what's in it.
Right,
I have a
well,
problem with that,
Okay.
particularly with that particular
Okay.
exhibit.
Okay.
Or I have a problem with him talking to you about it. Just, I kind of think that was already a part of the record at the lower level.
well, I don't think the defense lawyer that tried the case introduced this or used this at trial.
But I think it's part of the,
I don't,
No, I don't think it is. I won't come through it. I could be misremembering, but if it's anywhere, it's in the clerk's record. But I believe I only found that in the state's file from the Public Information Act request. Yeah.
and then, so that's
Okay.
that. And then the other one is it's some, I guess these are CPS records. And I can't find the page right now, but there is a couple of statements in the CPS records. This is about the older sibling of Caitlin,
Okay.
who who apparently had some broken ribs. And there are some statements in the CPS records where the mother of that child, who is also the mother of Caitlin, told the CPS worker
Hang on.
that
Do you have,
yeah,
well,
Judge, here's my thought process on this. As in, I think from an advocacy, but on my advocate half of the state, and from a purely academic standpoint, this is, I'm objecting to the fact of the relevance for this proceeding.
well, I don't know that he's saying they're relevant for this proceeding,
I'm
correct?
not, I'm
You're
just
saying that you want
want the record for the Court of
for
Criminal
the court of
Appeals
criminal
in case
appeals.
they want.
It's already in the record. He's simply said it. I object to this.
If they're already in the record, then
No,
I'm
I'm saying-
duplicating it. but-
Because you're reading it.
Because you're,
kind of
Oh, I'm
different.
sorry.
because you're.
So I guess that's what I'm trying to stop you, is if you don't, I mean, I'm obviously aware of and have the ability to know something and not take it into consideration.
Okay.
I know we tell juries to do that. I know that's difficult, but I guess if you can just tell me less information about each one of those. So we've got 15, we've got
15,
16 as CPS.
CPS.
We've got, what else?
That's it, just those two.
Okay, so what I would be inclined to do is admit those really for record purposes only, and not for me to take into consideration, and I will not take those into consideration, but I don't think, what I don't want to happen on any of this is for something to come up and I say, no, it doesn't go up. And then the next thing we get is the Court of Criminal Appeals telling me, you should have just sent it up. Don't look at it, but send it up. So I'm gonna send it up. Your objection is taken into consideration, but 15 and 16 defense / appellant will be admitted for record or appellate purposes only.
Okay,
Judge, Not
that's
putting,
fine.
not putting me
That's
on the court's ruling, but just to kind of take this to its natural conclusion, Judge, where's the line? I mean, if we do that for them.
I think we're done.
I'm done.
Okay.
Is there anything you want? I mean, tell me now, we'll send it up. I mean, I don't disagree that there are potentially important things, and the last thing I want is for something to be brought up and then them say, send it back and we're here again over something as really minor as letting them see something if they want to look at it.
That's all I have on that. Then
Perfect.
I do, and I'm sure the court has your own list of things to talk about, but I do think that where we are now is we need to figure out doing Dr. Oppoven's testimony. I believe we have an agreement to do that by Zoom.
That's my understanding, is the agreement is to do it by Zoom. And Ms. Gilbert, did y'all get more
we've got-
information about her dates?
The dates for Zoom, when she is available, is May 11th or May 8th, if that works for the courts.
So. Hold on 1 second, let me pull up that calendar. So the 8th is a Friday,
That's right.
and that's the week of, So. Any time
Uh,
constraints on, I mean, we can get her done early in the morning.
See why not?
No time constraints, Your Honor. Would we be coming in person to then have Dr. Alcoven testify?
We like coming to Beaumont, but could we be on Zoom too?
I mean, if she's on Zoom, honestly, if one person's on Zoom, it's probably easier for logistics and for the court reporter if everyone's on Zoom. Because she and I can be here in the courtroom and have it on the screen so she can see everybody's voice. Mr. Coleman obviously is here and upstairs. If you would rather be, like we've done on some of our preliminary hearings, if you want to be here in the courtroom, you're welcome to do that. So I don't have a problem if we're gonna
I don't
let
have
her
problem-
Zoom.
If she's on Zoom, I don't have a problem with it.
Okay.
Judge, I just want to inquire, I mean, so what you're representing is that a month from now, Dr. Oppoven will still be suffering from the same infirmity and situation that you represented at the outset.
She had surgery last week. Was still on pain medication this
But
week.
I mean,
She-
just just yes or no, I mean,
I-
you're representing that she's still gonna be under the same infirmity restrictions as.
We believe, based on her age and her health status and the fact that she just had surgery, that will be very difficult for her to travel down here.
Okay, there's already been an agreement on the record that she could come, so we're not gonna go backwards on that.
It was contingent, but I get it.
That
Yes,
there
ma'am.
was no
I'll let it-
contingencies mentioned to the
I will
court.
let it go,
That
Judge.
was agreed.
Yes, ma'am.
We're not going backwards. She is going to testify by Zoom. I would like, I guess, obviously no one knows specifically how long testimony would take. What is the anticipation with regard to her
It
testimony?
will not take as long as Dr. Galasnik. I think it will be more like the state's experts than it was like Dr. Galasnik. Do you agree with that?
Yes.
Yes. Okay.
Any reason to disagree that you know of, Mr. Coleman? You guys can all have a seat. Thank y'all. So let's then plan. Let me do this. Let me send something out to you guys either later this afternoon or early next week. But I want to look at, I'm pretty sure I have trial the week of the 11th. I have a jury.
That's what I was.
Is that what you, if for some reason I don't have it here, but so I would think that the morning of the 8th would probably work better so that I can go ahead and do my regular docket and have jury selection Monday, the 11th. So never mind with me getting back to y'all. Let's just do it Friday, May the 8th. And I would say, let's get started. Anybody have a problem with getting started at 8:30?
No, that's fine.
Okay, let's get,
My preference would be 9, but I defer.
okay. Let's get started at 8:30 on the 8th. And then what I intend to do by giving myself a deadline here, by next Wednesday, so a week from today, I will let you all know if I intend to use the affidavits of those 3 additional witnesses that the applicant has requested I use, or if I want any of them, one or all or some, to testify in person. And if we do that, then we may have, we may go into that next week and obviously need to be here in person, and I'll get rid of my trial or whatever we need to do. But I will, after I get back, I'll get with Mr. Florence. I'll kind of go through and reevaluate where I am, what I've heard, and if I think in-person testimony would be helpful for me, or if I'm good with the affidavits.
Did we ever establish when you want proposed findings of fact, conclusions of law?
We have not,
I mean, if you want to get back with us.
well, I mean,
Concern, that's a question.
I would say that you guys, obviously, I think the bulk of everything that is going to be heard, primarily other than potentially the affidavit people, and obviously, Dr. Oppoven, did I say it right finally? You guys could probably start, but as far as a deadline for that, let me get y'all that deadline also on Wednesday. Once I have a better idea of what in person we're going to need, if any. But I think that would make a difference.
We had discussed calling Dr. Galasnik and rebuttal. We're not going to do that.
Thank you very
We're-
much. Okay.
from that.
Okay, so I've given myself a deadline next Wednesday to let you guys know about the affidavits as well as kind of a timeline. Once we know that, that'll make a timeline easier for you guys to submit your proposed findings of facts. Anything else?
Yes, Your Honor, is there any sort of capability for Mr. Garner to view a portion of Dr. Alcoben's testimony? Since we won't be here in person at the county jail, or is that something I can ask the jail about when I go?
Yeah, I don't know whether they'll have him back. I mean, he can go back to his prison unit. And then if there is a way to set it up. in the
Well,
prison
but they
unit.
said there they would only do it for 1 hour, which is why we had to get them here.
Oh,
We absolutely have the capability of Zooming from our jail because I helped set that up during Zoom. I mean, during COVID. So we can for sure, and or if there's any issue at all with getting them hooked up to Zoom, we can have Mr. Gardner brought over. He can sit in the courtroom with us during that, see it on the screen. We'll make sure that he's able to either see it here in the courtroom and or at the jail, and we'll test that at the jail before that day so we don't run into any issues.
and I just want to check one thing with Mr. Garner to make
Sure.
sure you understand that you may wind up being stuck here in the county jail and then that's something you're good with that. Okay, we're good.
Okay, all right, and okay. Let me write that down too. Zoom, jail. What else do I need to what else do we need to do before we?
I don't have
Break.
any, I don't think, is anything else? Ed?
Everything's
We're
good.
good.
Well, thank you all very much. This was a kind of a long 3 days, I think, for everyone, but I do appreciate everyone's patience with me and your patience with my impatience. All right, we'll be adjourned.